Hello, everyone, and welcome to Uncivil Law. For today's case, we are reviewing a district court's decision in the case of Ghassan al-Assad versus the Department of Homeland Security. In this case, the district court found that the federal government went too far in conducting a search as part of an immigration customs enforcement. Here, customs was searching cell phones by going into the phones and getting data from the phones, and the court said that this was actually improper. This is a very unexpected decision, actually. The United States government enjoys quite a lot of leeway at border, so it's quite unusual for a court to strike down a search as being improper. So we're going to read the reasoning of the district court as it relates to this and see what happened. Plaintiffs, 10 U.S. citizens and one permanent resident, alleged the defendant's conduct searching the plaintiff's electronic devices at port of entry to the United States, and in some instances confiscating the electronic devices being searched pursuant to policies violates the Fourth Amendment. Although governmental interests are paramount at the border, where such non-cursory searches, even basic searches as broadly defined under policies, as well as advanced searches, amount to non-routine searches, they require reasonable suspicion the devices contain contraband. It's pretty unusual for a court to say that reasonable suspicion is required for a border search. Normally, reasonable suspicion is not required for a border search. They're checking for contraband. They can just check stuff. So for them to say that you do need reasonable suspicion is pretty unusual for a court. The material facts concerning the searches of the electronic devices and the policies pursuant to the statutes are undisputed. The two agencies with primary responsibility for border searches are Border Protection and ICE. Both agencies have written policies. In 2018, Border Patrol updated its policy to distinguish between two types of searches, basic and advanced, and to require reasonable suspicion or national security concern for an advanced, but no showing of cause for the basic search. Under this policy, an advanced search is defined as any search in which the officer connects external equipment through wired or wireless connection to an electronic device, not merely to gain access to the device, but to review, copy, and analyze its contents. The parameters of an advanced search are clearer given this definition than that adopted for the basic search, which is merely defined as any border search that is not an advanced search. Both Border Patrol and ICE use the same definitions. Each of the 11 plaintiffs have and even if it is arbitrary and capricious, the government power at the border is at its zenith. So it may be like the place where the exception tests the rule, because governmental power at the border is pretty high. So it may be an exception to the rule. Each of the 11 plaintiffs has had their electronic devices searched at the border. Some of the searches were at border crossings, although most were at U.S. airports. The search of electronic devices included laptop computers. 5 of the plaintiffs had their electronic devices searched more than once. 2 of the plaintiffs had their devices searched during subsequent filings. A guy named Merchant is the founder and editor of a media website and has had her phone searched during multiple times despite her concerns about them seeing pictures of her without her headscarf on. Merchant observed the Border Patrol viewing communications between her and her lawyer. Dupin's phone contained information from his work as a journalist, while Bikanar's phone was a work phone officially owned by NASA. It is undisputed that information gleaned by Border or ICE during certain of these border searches have been retained, so they've retained the information. Information observed by the agents during the search has been retained. Reports containing such information note not just the fact that they conducted the search, but in some instances, observations and characterization of the information contained therein. The court denied the defendant's motion to dismiss, concluding the plaintiffs had set forth a plausible Fourth Amendment case. In ruling on the defendant's motion to dismiss, the court ruled the plaintiff had demonstrated standing by plausibly alleging an injury in fact traceable to defendant's alleged conduct that was likely to be redressed by a favored decision by the court. Moreover, the record regarding a substantial risk of future harm has been borne out. The current records show that agents have potentiality to access information on the past searches, and such information may be used to inform future searches. The recent additional search of Ali Bad's device on July 6, 2019, furthers plaintiff's argument as to the risk of future harm. Ali Bad had been subject to a border search in 2017. When he declined to provide the password to his locked phone, Border Patrol seized it to conduct an examination. Ali Bad arrived at Toronto Airport for a flight to Dallas, traveling with a smartphone and laptop. The officer searched both devices. That such search of the electronic devices continues for plaintiff in the midst of their ongoing legal challenge to the same serves as further indication that this will continue. Plaintiffs challenge both the constitutionality of their search and the claim that Border and ICE allow for border searches of electronic devices without warrant, even as these policies still require no showing and now reasonable suspicion for the advanced searches. The border search exception, grounded in the recognized right of the sovereign to control, subject to substantive limitations imposed by the Constitution on who and what may enter the country, is an exception to the general Fourth Amendment rule. As previously observed by this court, the border search serves the nation's paramount interest in protecting its territorial integrity. The rationale supporting the border search exception are the sovereign's interest in protecting the integrity of the border by regulating the collection of duties and preventing the introduction of contraband into this country. Travelers may be stopped because of national self-protection reasonably required, one entering the country to identify himself as entitled to come in and his belongings and effects to one that may be lawfully brought in. Supreme Court has characterized customs officials' role at the border as greater than that of investigative law enforcement, explaining that customs officers are also charged with protecting this nation from entrants who may bring anything harmful into this country, whether that be communicable diseases, narcotics, or explosives. Absent more precise guidance from the founding era, we generally determine whether to exempt a given type of search exception from the warrant requirement by assessing, on the one hand, the degree to which it intrudes upon an individual's privacy, and on the other, the degree to which it is needed for the promotion of a legitimate interest. That is, the border exception is not limitless and must still be reasonable and subject to the same balancing level of intrusion upon an individual's privacy and necessity for the promotion of a legitimate governmental interest. I am sadly forced to disagree with the court as much as I really want to, because I think the amount of searches that they do are completely over the top. But I don't think reasonableness really applies at the border. The border is a place where the government has unbelievable amounts of power. Like, normal constitutional guidelines completely break down. First Amendment guidelines break down at the border. It's a place where things are at their zenith. So I'm not sure any reasonableness is really required for these kinds of searches. So I don't think the court is right here. I think the court's going to get overturned on appeal. I really do. It's very sad but true, I think. You don't always get to reach the decisions you want to reach, guys. It's a sad fact of law. What the border search exception recognizes, rather than a limitless ability to conduct searches in connection with international travel, is that individuals have a reduced expectation of privacy at the border when the government's interest in preventing entry of unwanted persons and effects is at its zenith. Defendants have a paramount interest in maintaining territorial integrity at the border. They define such to include responsibility to ensure interdiction of persons and goods illegally entering or exiting the United States, facilitate and expedite the flow of legitimate travelers and trade, administer the enforcement of customs and trade laws, detect, respond to, and interdict terrorists, drug smugglers and traffickers, human smugglers and traffickers, and other persons who may undermine the security of the United States, and enforce the immigration laws. Defendant further cites interests served by the border exception as helping to promote national security, prevent entry of criminals, inadmissible aliens, and contraband, facilitate lawful travel and trade. As to contraband, it is the interdiction of contraband, not evidence of contraband, that is paramount concern at the border, not evidence of contraband that might help future investigations. I don't know that I can agree with that conclusion. I mean, obviously, search serves both purposes. The purpose of Border Patrol is to seize things that shouldn't be here, but to suggest that they shouldn't or can't use those things as part of an investigation or to direct their future activities makes no logical sense. It's obviously the things that come in are going to provide them information that might lead to future investigations, might lead to future law enforcement investigations, might lead to future activities from customs themselves. So yes, their immediate objective is to seize the thing. But to suggest that that can't be used for further law enforcement purposes doesn't follow to my mind. When applying exceptions to the warrant requirement, courts must determine whether the search at issue is within the scope of the exception, whether the search furthers the underlying purpose of the exception, and whether the search, even if it's within the scope of the exception, intrudes upon competing privacy interest. Stopping an insect or smuggler would be a compelling reason, yeah, particularly for insects. I mean, we don't have to go very far to point out examples of wildlife making it into places where they don't belong and it not going well. So yes, seizing flora and fauna is well within the scope of Border Patrol's interests, yes. The record recites searches of electronic devices at the border have successfully uncovered threats to national security, information pertaining to terrorism, illegal activities, contraband, and inadmissibility of people and things without explaining the frequency and nature of it. As to contraband, there are limits to the contraband that may be stored on digital devices. The form of such contraband, as identified by defendants, can include child pornography, classified information, and counterfeit media, even as such devices may also contain evidence of the same. The record of prevalence of such digital contraband encountered at the border remains unclear. Given the dearth of information of the prevalence of digital contraband entering the United States at the border, the court cannot require showing of some cause to search would be an obvious deterrent. The Supreme Court has described the border search exception as applying to routine inspections and searches of individuals or conveyance seeking to cross the border. Routine searches of persons and effects are not subject to any requirement of reasonable suspicion, probable cause, or warrant. This is what I was saying earlier. I mean, the idea of any need of reasonable suspicion at all for any sort of routine search is just not applicable at the border. The government has all kinds of power at the border, so, that's completely right. Non-routine searches, by contrast, require reasonable suspicion. The distinction between routine and non-routine does not turn upon the frequency or the label, but the invasiveness. So let's watch now as the district court tries to desperately cram this into the non-routine category. Let's see how that goes. The ICE and Border Patrol policies cover the gamut of electronic devices. The policy defines an electronic device as any item which may contain information: computers, disks, drives, tapes, mobile phones, and other communication devices, cameras, music players, and any other digital device. Smartphones and laptops, devices that the plaintiffs were carrying, can contain information such as photographs, contacts, emails, text messages, as well as information such as prescriptions, employment information, travel history, and internet browsing history. Here, information on the devices when the devices were searched include attorney-client communications, pictures of the plaintiff, and information on journalism work. In the Supreme Court case of Riley, the court analyzed the applicability of the search incident to arrest exception to a search of arrestee's cell phone and held that officers must secure a warrant before conducting a search. So that was a pretty big U.S. Supreme Court case, I think from 2 terms ago, where they held that when you conduct a search of a cell phone pursuant to a routine arrest, in order to actually get into the cell phone and look at the contents of the cell phone, you need to get a search warrant. That's not typically true in most cases. It was a pretty big exception the day the Supreme Court made that decision to say that, because cell phones contain so much information, you need a warrant requirement. The problem is that in Riley, it was a search. The problem was that in Riley, it was a search pursuant to an arrest. Here, it's a search pursuant to being at a border. And because the power of the government is so much higher at the border than even during a normal routine arrest, I don't think the logic quite flows. Modern cell phones as a category implicate privacy concerns far beyond those implicated by the search of a cigarette pack, a wallet, or a purse. The Supreme Court further noted later in the opinion that a cell phone search would typically expose the government to far more than the most exhaustive search of a house. Defendants have also pointed to broad latitude border officers have to search physical items, but comparisons to searches for digital evidence or contraband searches of other physical items are inopposite. The court's reasoning in Riley holds the same force when applied to border searches. Okay, guys, the district court's decision basically comes down to the truth of that one sentence. That's the entire linchpin of this decision, in my opinion. It's whether or not that sentence is true. Does the logic of Riley apply to borders or not? Does the logic of Riley that says that cell phones are special because they contain lots of information and therefore it's not like searching other stuff, does that logic apply at the border when the power of the government is at its zenith at the border? I'm not sure the logic follows. I really want it to follow. I wish it would follow, but the power of the government at borders is so high that I don't think you can just map one onto the other. It's not as simple as saying it said it in Riley and we can apply it here. It's an upstream application. It doesn't quite map. And so everything basically boils down to whether or not that sentence is true. And I don't think it probably is given the precedent that I know about. So as much as I wish it was, I don't think this decision is going to stand. Unlike a vehicle, vessel, or even home, at the border, the data stored on a cell phone is distinguished from physical records by quantity alone. Basic searches, defined only as any search of an electronic device that's not advanced, can access content from space physically resident on a device using the device's native operating system. That is, even a basic search alone may reveal a wealth of personal information. Electronic devices carried by travelers, including smartphones and laptops, contain a very large volume of information, including sensitive information. Even in a basic search, agents can pursue and search the contents of the device using the native search function and available keyword search. This court does not dispute that a cursory search of an electronic device, a brief look reserved to determining whether a device is owned by the person carrying it across the border, confirming it's operational and that it contains data, would fall within the border search exception and not require a heightened showing of cause. However, the range of searches that the plaintiffs were subject to and the breadth of searches that continue to be permitted, even as basic searches under the current policies, are not such routine searches given the breadth of the intrusion into the personal information. Since Border and ICE have adopted their policies in 2018, the electronic devices of some plaintiffs have been searched in what have been described as basic searches. An advanced search can generally reveal anything that would be discovered during a basic search. In addition to revealing data, an advanced search may also be used to uncover deleted or encrypted data and copy the information on the devices used. I think you probably could, on the case law, distinguish between the simple search and this more advanced search, because copying the data and that kind of stuff does seem way more intrusive than a typical routine search. So you probably could distinguish it on the case law based on that. But as to this simple search and just doing a routine search in like a search app, I don't know, man. Given the case law, and the power of the border, I'm not really finding the decision to be perfectly persuasive. On this record, and as the plaintiffs contend, the court is unable to discern a meaningful difference between the two classes of searches in terms of privacy interests implicated. The concerns laid out in Riley of unfettered access to thousands of pictures, location data, and browsing history would have qualified as a basic search, apply with equal force to basic and advanced searches, particularly as the device's native operating system becomes more sophisticated and most closely recognizes the capabilities of an advanced search. In light of the record, case law, and conjunction with the lack of meaningful difference between basic and advanced, this court concludes that agents and officials must have reasonable suspicion to conduct their search. So that is the case of Ghassan al-Assad versus the Department of Homeland Security. In this case, we learned several things. First, that Border Patrol is conducting both basic and advanced searches of cell phones, laptops, and other searches. In basic searches, they are using the built-in operating system and built-in search function to search the phone for things that they find interesting. In advanced searches, they copy the phone wholesale and look for deleted phones and retain the data for later use. In either case, the plaintiffs have argued this violates their rights. They have cited the case of Riley, a United States Supreme Court case which held that pursuant to a lawful arrest, a routine search of a cell phone was excessive and it did require a warrant. The district court here has applied that decision to the border. Unfortunately, I believe that this decision is ultimately incorrect. The power of the government at the border, given the case law, is so high that I don't think that the logic of Riley automatically applies, at least as it relates to the basic searches. Perhaps for the advanced searches where data is being kept wholesale and copied wholesale, that would be something where the logic might apply. But as to basic searches to see if there's any contraband on the phone, I think that probably passes the muster of the Supreme Court's test, given the power of the border, even though it didn't pass muster in the case of Riley. You can distinguish on the factual background of border versus arrest. And so we will keep track as this case moves through the system and see what happens next.